centuries, human societies have wrestled with a foundational political question. Where should ultimate authority come from? Divine law or the consent of the governed? Today, that question comes to life in a direct debate between two political frameworks that have shaped billions of lives. Islamic governance, rooted in Sharia and centuries of Islamic political thought, and secular constitutional democracy, rooted in Enlightenment political philosophy. Joining us, an Islamic political scholar and expert in Islamic law, and a political scientist and secular constitutional scholar. Each will draw on primary sources, historical governance models, and comparative political science to make their case. Here's the format: 2 minutes each for opening statements, then cross-examination timed at 3 minutes per response. A 2-minute rebuttal round follows, and finally, 5 minutes each for closing statements. No winner will be declared today, just 2 rigorous cases for you to weigh.
Round 1.
Thank you. Islamic governance rests on a core claim secular systems don't share. That law, derived from divine revelation, provides a more stable, transcendent standard of justice than law derived purely from shifting human consensus. Sharia, properly understood, isn't merely a legal code, it's a comprehensive ethical framework covering worship, personal conduct, economic justice, and governance, drawn from the Quran and the practice, Sunnah, of the Prophet Muhammad. The Quran repeatedly commands rulers toward justice. Indeed, Allah commands you to render trusts to whom they are due, and, when you judge between people, to judge with justice. Surah An-Nisa 458. The Prophet is recorded in Sahih al-Bukhari, stating, "Each of you is a shepherd, and each of you is responsible for his flock," establishing rulers as accountable trustees, not absolute sovereigns. Historically, classical Islamic governance developed real institutional accountability mechanisms, the hisbah, a public office overseeing market fairness and public ethics, bayt al-mal, a state treasury funding welfare through zakat, and the qadi al-mazalim, a grievance court where citizens could bring complaints even against rulers themselves. Classical scholars like Al-Mawardi, in his 11th century work, Al-Ahkam al-Sultaniyya, systematized the qualifications and accountability structures required of legitimate Islamic rulers, while Ibn Khaldun's Muqaddimah offered a sophisticated, empirically grounded analysis of how states rise and fall based on social cohesion, asabiyya, and just governance. Islamic political thought also emphasizes consultation, shura, commanded directly in the Quran, and consult them in the matter, Surah Al-Imran 309. I'll be direct about where this debate gets genuinely difficult. Historical Islamic governance was never uniformly democratic in the modern sense, and I don't think honest scholarship should claim otherwise. My argument is narrower, that a legal ethical system grounding governance in transcendent justice and consultative accountability offers something secular positivist law, which can be rewritten by whatever majority or authority currently holds power, structurally lacks.
Thank you. Secular constitutional democracy rests on a foundational insight developed across centuries of political philosophy. Legitimate political authority derives from the consent of the governed, not from any single religious, monarchical, or ideological claim to transcendent truth. Precisely because reasonable people disagree, sincerely and permanently, about ultimate religious questions. John Locke, in his second treatise of government, argued, government exists to protect natural rights, life, liberty, and property, through a social contract that can be revoked if government fails that trust. Montesquieu's Spirit of the Laws gave us the separation of powers, executive, legislative, judicial, specifically to prevent any single authority, religious or otherwise, from accumulating unchecked power. John Rawls, in A Theory of Justice, proposed evaluating a political system's fairness from behind a veil of ignorance, not knowing in advance which religion, class, or group you'd belong to, a powerful tool for designing institutions that protect minorities rather than assume majority religious consensus. Secularism, properly understood, doesn't mean hostility to religion. It means the state remains neutral among competing religious and philosophical worldviews, protecting each citizen's freedom to practice, or not practice, any faith equally under a shared, religiously neutral legal framework. This matters enormously in religiously plural societies. John Stuart Mill's harm principle from On Liberty holds that the only justification for restricting individual liberty is preventing harm to others, not enforcing any single group's including a religious majority's moral vision on everyone. Empirically, comparative political science generally finds constitutional democracies with strong separation of powers correlate with stronger protections for religious minorities, women's legal equality, and peaceful transfers of power than systems where a single religious legal framework holds constitutional supremacy. Though I'll be careful throughout this debate not to overstate that correlation, since economic development, colonial history, and regional context are also powerful, often larger, explanatory factors genuinely tangled up in these outcomes.
Round 2.
If Sharia is applied as the supreme legal framework of a state, how does a genuinely non-Muslim citizen, an atheist, a Christian, a Hindu, participate as a fully equal citizen, with an equal voice in shaping the state's fundamental laws, rather than living under a legal order derived from a religious tradition not their own?
This is the single most important practical question in this whole debate, and I want to answer it honestly rather than idealize the historical record. Classical Islamic governance developed the dhimmi system, granting non-Muslim religious communities legal autonomy over their own personal and religious affairs, marriage, inheritance, worship, under their own religious courts in exchange for the jizya tax and acceptance of certain restrictions that, I'll be candid, varied significantly across history, from relatively light in periods like Abbasid Baghdad and Islamic Spain to considerably harsher under rulers like the 12th century Almohads. That system did not offer full equal citizenship by modern standards, and I don't think it's intellectually honest to claim it did. Where contemporary Islamic political thought has genuinely moved is toward frameworks separating this classical dhimmi model from equal constitutional citizenship. Many modern Muslim-majority states and Muslim scholars now argue for full legal equality of all citizens regardless of religion, while still drawing general ethical and legal principles from Islamic sources for majority Muslim social and family law, similar in structure to how many secular states retain religiously influenced holiday calendars or moral assumptions in law without claiming full religious neutrality either. I'd concede this remains a genuinely unresolved tension within contemporary Islamic political thought, not a fully solved problem.
Contemporary states applying Sharia-based criminal law most directly, including corporal and capital punishments, for offenses like apostasy or blasphemy in some jurisdictions, face substantial documented human rights criticism from international bodies. How does Islamic political thought respond to the argument that these specific applications conflict with modern human rights frameworks most of the world, including many Muslim-majority states, have formally endorsed?
I want to engage this directly rather than deflect toward generalities. It's true that specific criminal applications of Sharia in some contemporary jurisdictions have drawn substantial, well-documented human rights criticism, including from international human rights bodies and from many Muslim scholars and jurists themselves. I'd make 2 points. First, there is real, serious internal Islamic scholarly debate, not just external criticism, over whether classical criminal penalties, hudud, were intended as a permanent universal legal mandate or were shaped by specific historical and evidentiary contexts with an extraordinarily high evidentiary bar, classical jurisprudence itself built in, making actual application historically rare. Some contemporary Muslim legal scholars argue modern state implementations often depart significantly from those classical procedural safeguards. Second, I think it's fair to distinguish between Sharia as a broad ethical legal framework emphasizing justice, welfare, consultation, and accountability, which is the core of my argument today, and specific criminal code applications in particular modern states, which represent one contested implementation choice among Muslim-majority countries, not a single unified position all Islamic political thought endorses uniformly. Reasonable, serious Muslim scholars disagree sharply on this question, and I don't think it's honest to present it as settled within Islamic jurisprudence itself. Secular constitutional democracy claims neutrality among competing moral visions, yet secular legal systems still make binding moral choices, yet on abortion, marriage, drug policy, economic redistribution, reflecting whatever majority coalition currently holds legislative power. Isn't the claim of true religious or moral neutrality something of an illusion, given that secular law inevitably encodes some substantive moral framework too, just not an explicitly religious one.
This is a serious and frequently underestimated challenge to secularism, and philosophers of law take it seriously rather than dismiss it. You're right that pure moral neutrality is, strictly speaking, impossible. Any legal system makes substantive choices. What secularism actually claims is narrower and more defensible. Not that law is value-free, but that lawmaking authority shouldn't rest on any single religious tradition's specific theological claims, as its stated justification, and that citizens of any or no religion should have equal standing to participate in shaping those laws through shared civic institutions, using publicly accessible reasoning rather than sectarian religious authority alone. Rawls addressed exactly this concern with his concept of public reason. The idea that in a pluralistic society, coercive laws should be justifiable using reasons all reasonable citizens, regardless of their private religious commitments, could in principle accept, rather than one group's revealed truth binding everyone else. I'd agree this ideal is imperfectly realized in practice. Every real secular democracy falls short of it to some degree. But the aspiration itself and the institutional mechanisms built to pursue it, like judicial review protecting minorities from pure majoritarian religious imposition, are meaningfully different from a system where a specific religious legal tradition holds constitutional supremacy by design.
Secular constitutional democracies, including well-established ones, have historically produced deeply unjust outcomes too. Chattel slavery upheld under secular constitutional law in the United States for generations. Colonial exploitation administered through secular legal frameworks and contemporary wealth inequality that secular market democracies have struggled to meaningfully address. Doesn't this undercut the claim that removing religious grounding from law reliably produces more just governance?
You're right, and I won't minimize it. Secular constitutional systems have produced serious historical injustices, and pointing that out is a legitimate and important challenge, not something I'd wave away. I'd make two distinctions in response. First, secularism as a political philosophy doesn't claim any specific outcome is automatically guaranteed. It claims a particular procedural structure, separation of powers, protected minority rights, mechanisms for peaceful legal reform, which historically has, however imperfectly and slowly, provided the internal tools used to correct those very injustices from within the system itself through constitutional amendment, judicial reinterpretation, and expanded suffrage, rather than requiring revolution or external religious authority to do so. American chattel slavery, for instance, was ultimately abolished using the same secular constitutional machinery, legislative and judicial reform, that had previously permitted it, which I'd argue demonstrates the system's capacity for internal correction, however tragically delayed, more than its fundamental failure. Second, on inequality, this is a genuine, serious, ongoing challenge across essentially all political systems, religious and secular alike, and I don't think secular democracy has a uniquely strong answer to it. Rawls' own work on distributive justice was largely motivated by recognizing exactly this gap in existing secular liberal frameworks, which remains actively debated and unresolved within secular political philosophy itself today.
Round 3. Rebuttals. I want to focus on the strongest point raised today, that true moral or religious neutrality in secular law is, strictly speaking, impossible, since every legal system encodes substantive values, a point my colleague candidly conceded rather than dismissed. I think that concession is significant, because it suggests the real disagreement between our two frameworks isn't value-laden law versus neutral law, no such neutral law exists, but rather which source of values and which accountability mechanism for revising them produces more just and stable governance over time. Where I'd push back is on the assumption that publicly accessible secular reasoning is inherently more reliable or less contestable than transcendent legal principle. Secular majorities have, as discussed, produced serious injustices too, revised only slowly and imperfectly. I don't think either tradition has a clean, injustice-free historical record to point to as decisive proof of its framework's superiority.
I appreciated the candor regarding the historical dhimmi system's real limitations and the acknowledgement of genuine internal Islamic scholarly disagreement over criminal law applications. That kind of honesty is exactly what this comparison requires, rather than idealized narratives on either side. I'd push back on one point. My colleague is right that no legal system achieves perfect neutrality, but I'd maintain a meaningful distinction remains between a system whose foundational constitutional authority rests explicitly on a single religious tradition's revealed law, and one whose foundational authority rests on revisable, publicly justified civic consensus, even if that consensus is itself imperfect and value-laden. The difference matters most, I'd argue, for religious minorities and dissenters specifically. Under the second model, they participate as equal architects of the law itself. Under the first, even with historical accommodations like the dhimmi system, they participate as accommodated subjects of a law whose ultimate source lies outside their own tradition. That structural asymmetry, I think, is the crux of our disagreement today.
Round 4. Final statements. I want to draw together what I think today's exchange has genuinely clarified, rather than simply restate my opening. Both political traditions we've discussed claim to pursue justice, accountability, and human flourishing, and both, honestly examined, have fallen short of those aims in specific, historical, and contemporary instances. I don't think either of us has denied that today, and I think that mutual honesty has made this a more useful conversation than a simpler, one-sided version would have been. My core claim remains this: Islamic governance, at its best, grounds law and political authority in a transcendent standard of justice, commanded consultation, shura, ruler accountability modelled on the Prophet's own teaching, and institutionalized welfare through zakat and the bayt al-mal, that doesn't depend on whichever political coalition currently controls legislative power for its legitimacy or its basic moral content. Classical scholars like Al-Mawardi and Ibn Khaldun developed genuinely sophisticated theories of legitimate authority, accountability, and the social conditions under which states flourish or collapse, centuries before comparable secular enlightenment. Political theory existed. I've tried today to engage honestly with this framework's real historical and contemporary tensions. The dhimmi system's genuine limitations regarding full equal citizenship, serious internal Islamic scholarly disagreement over criminal law applications in the modern era, and the reality that Islamic political history was never uniformly consultative or accountable in practice. I don't think naming those tensions weakens the underlying case. I think refusing to name them would. What I'd ask viewers to weigh is this: is grounding a political and legal order in a claimed transcendent, unchanging standard of justice, imperfectly implemented across history, as every political system is, a structurally weaker foundation for good governance than grounding it in revisable human consensus, which has also, as we've discussed today, permitted serious injustice at various points in its own history? I don't think the answer favors either tradition automatically. I'd ask you to examine specific historical and contemporary governance outcomes for yourself, tradition by tradition, case by case, rather than accepting either side's account of its own record uncritically.
I'd echo that spirit of mutual honesty. What today's conversation showed, I think, is that this isn't really a debate between a just system and an unjust one. It's a debate about where legitimate political authority should ultimately originate, and how a political system should handle deep, permanent, sincere disagreement among its own citizens about fundamental religious and moral questions. My argument throughout has rested on this: constitutional democracy's core institutional innovations, separation of powers, protected minority rights, revisable law through legitimate civic process, public reasoning accessible across religious lines, were specifically designed to handle exactly the kind of deep pluralism that characterizes almost every modern society, including, notably, many contemporary Muslim-majority states themselves, which are rarely religiously homogeneous internally. Locke's argument for religious toleration, Montesquieu's separation of powers preventing any single authority's overreach, and Rawls' framework for justifying coercive law across religious lines all address a problem I don't think classical. Islamic political theory, developed in a different historical context of much greater assumed religious homogeneity, was originally designed to solve in the same way. I want to be fair to what was raised today, though secular constitutional democracy's historical record includes serious, well-documented injustices, slavery, colonialism, persistent inequality, and I don't think its procedural design guarantees good outcomes any more automatically than Islamic governance's transcendent legal grounding does. What I'd argue distinguishes the secular model isn't a cleaner historical record. It's a specific institutional commitment to keeping political authority permanently revisable by and accountable to all citizens equally, regardless of their particular religious commitments. A commitment that, I'd argue, becomes especially important precisely in societies, which is most societies today, that are not religiously uniform. I'd ask viewers to consider both systems not as abstract ideals, but as they've actually functioned across real historical and contemporary cases, and to weigh honestly which approach best protects both majority self-governance and minority rights in the specific society you're evaluating, rather than assuming either framework's stated principles automatically translate into its lived practice.
Today we explored two competing visions of legitimate political authority. One grounds governance in transcendent divine law, consultative accountability, and centuries of Islamic legal and political scholarship. The other grounds governance in revisable civic consensus, separation of powers, and centuries of Enlightenment political philosophy. Both traditions, honestly examined today, have pursued justice, and both have, at points in their history, fallen short of it. The evidence, arguments, and historical record are now presented before you. The question remains, which framework provides the stronger foundation for just, accountable governance? You decide.